Well, good afternoon, ladies and gentlemen. Dear colleagues, if you could resume. Welcome back to this penultimate session of the very rich two-day conference. And here, I think I'm allowed to renew our gratitude to Ellen and Eric for organizing this conference. And since this is the penultimate session after a wonderful lunch, our biggest task is, of course, to keep you all awake until the end. And for this, I'm sure that we have three wonderful panelists which will stay you not only awake, but excited. First, we have Paasivirta, who is a legal advisor in the European Commission. He has been working on general international related issues and published extensively, for example, on international responsibility of the European Union recently, and it's, of course, international responsibility of member states. And today he is going to share with us his experience and insights as an insider of the European Union, particularly European Commission concerning dispute settlement. And the European Union, as you know, has the exclusive competence in the conservation of marine biological resources under the EU Common Fisheries Policy, and is a party to the United Nations Convention on the Law of the Sea, but also to several regional fisheries management organizations, RFMO. So we have many abbreviations, UNCLOS, BBNJ, etc. But I think the RFMO is one of the most difficult ones to pronounce. Well, so let me give it a try. And we have Rosemary Rayfuse for RFMOs. Rosemary is a professor of international at the University of New South Wales, Australia, but also in Sweden at Lund University and at the University of Göteborg. She is also a member of the IUCN Commission on Environmental Law. Rosemary has been doing extensive research on environmental issues, covering, for example, ocean governance, high seas fisheries, and protection of the marine environment. She wrote a chapter on regional fisheries management organization in the Oxford Handbook of the Law of the Sea a few years ago, and is here today to give her analysis on the dispute settlement in RFMOs. And last but not least, we have Michael Lodge, who is the Secretary General of the International Seabed Authority. If I give you another abbreviation, ISA. He is a barrister of Gray's Inn and has very rich experience in practice, of course, in the ISA, but also at the OECD, as well as the South Pacific Foreign Fisheries Agency. It'll be extremely difficult to find a more appropriate person for his subject today, that is the International Seabed Authority and deep seabed disputes. So without further ado, I'd like to give the floor to the first speaker. Yes, I have the floor, please.
Thank you very much. To be a speaker after the lunch is a very challenging task. I'm not quite convinced if I'm the best candidate to break in it. So my presentation is, as I represent a regional international organization, the EU, my presentation partly covers the sort of law of the sea related disputes before EU judiciary. Most of them, what I'm mentioning, are actually pending disputes. And then I also go through just the international side of disputes which EU has been involved. It's a little bit this situation is that the puzzled person there is that if you are in a regional organization, many disputes come actually within the regional organization, and some others then you look internationally to another direction, like ITLAWs or Annex 7 arbitration, and so on. I understand most of the people in this audience, you are international lawyers, so I thought that you might be interested more to get an overview of the current basically court cases between EU judiciary which connect with UNCLOS related matters, And then I'm not going to stick for very long on any of them within the time limits. And then I'm saying a couple of words on our international situation. So this is basically, I call this is a map over troubled waters. It tries to adopt a bit more modest heading than for this conference, simply because this is very much an overview of things. How you see things from, let's say, Brussels or Luxembourg. So there are a whole lot of maritime disputes before EU judiciary. Some of them are more interesting to people like you, some are less interesting. The basic parameters is that the dispute between the member states. I think the two cases that are there mentioned, they are somewhat of the parameters to understand what member states may do from EU law point of view. The Planck case was already mentioned by Professor Oxman, is that there it concerned the well-known dispute between Britain and Ireland, UNCLOS-related dispute, and EU being party to UNCLOS. So it did go to different international tribunals. In the end of the day, dispute returned to Luxembourg, and the island was found to have actually violated the treaty obligation not to submit its disputes to other fora. The more recently, the Slovenia-Croatia arbitration, it's in the other end of things, is the 2016 procedural award is interesting because it gives a history of the matter. From EU angle, Commission was very much involved actually to getting the two disputing countries into international arbitration, because the EU doesn't have competence over boundaries, including maritime boundaries. So it was very much promoting international arbitration. But once the procedures have started, it put an end to its activity and left it in the hands of the tribunal. But obviously, from the Commission point of view, it's been followed very closely. But especially the procedural award gives a nice historical background, in a way, how EU actually got involved into an issue where it doesn't really have competence, but which was part and parcel of Croatia's accession to the EU, condition put that these land and maritime borders had to be settled. Now the next issue is, since the award is there, how to implement it. And basically, arbitration agreement, if I recall correctly, it gives 6 months to do it. But if one looks at media reports, it's not very encouraging. There is plenty of hot air around the outcome. So it's, that is the next step which is being issued, has to be addressed. If you have good ideas to how to get it through, they are most welcome. Then you have disputes relating to EU acts in different formats. Many disputes come from domestic courts. For EU lawyers, that you are very well familiar with that, but there may be, these preliminary requests may be interesting from law of the sea point of view, like the pending cases in Western Sahara campaign. There are 3 lines of cases relating to Western Sahara. One was already decided last December, which concerned an agricultural agreement between Morocco and EU, which was challenged by Polisario. That was decided, and in the end it was considered inadmissible for Polisario to be there. But it put some stringent conditions in the main body of the text, which then will be carried through one way or another in the future. This one on the Western Sahara campaign, there it really goes into to the core of the Western Sahara problem. There are pretty much all international law issues at the table, from UNCLOS to UN law to occupation to administration to treaty-making power, all possible things, and all in a sort of gray area of international law that are being addressed. Western Sahara Campaign is the British NGO, which is there at the High Court of London in a domestic case. So that raises lots and lots of international law issues. There was an oral hearing held a couple of weeks ago, and there should be Advocate General's opinion before the end of the year. The Prosperous Queen shipping, it's also a preliminary ruling request from Finnish Supreme Court, also pending. We are expecting oral hearing before the end of the year. And it raises the questions, basically, it concerns a Panama shipping company, and there was an oil spill in the Baltic Sea, and the Finnish authorities put an administrative fine on this company, and it challenged, and then it came from the Supreme Court of Finland to be decided. And it raises issues. They were basically looking at it from the viewpoint of 1969 Intervention Convention relating to oil spills and this kind of things. And it raises questions of how does that convention, to which Finland is a party, but many other member states are not parties, nor is the EU a party, how does it relate to UNCLOS? And there are particular notions that what are the coastal and related interests involved in that case. So there will be a comparison between two conventions, and it concerns particularly on Article 220, paragraph 6 of UNCLOS, because that UNCLOS came after the 69 convention, and at the time there was no EEZ, and this incident happened in the Finnish EEZ area. So the question is to look at these conventions, how do they relate to each other, and also to consider what is the status of Baltic Sea, which under MARPOL rules is considered as a particularly sensitive area. So that is the one element, or from international law point of view, which are being in the table. Then you have a lot of these cases are less interesting in the sense that maybe for you, but there is there, just for sake of completion, they a little bit describes how the Commission operates to implementing rules. Is that the first one with the Italy concerned use of drift nets by Italy, and the Commission brought it to the court, and basic problem was administrative incapacity in Italy actually to prevent use of those drift nets. It didn't raise, on the face of it, international law questions. There were EU rules in place, but it's an example how the Commission exercises its supervisory role. Then there are these sort of administrative enforcement cases. They come quite regularly because every year you decide on the quotas for the member states, and and then it shows that afterwards somebody has been overfishing. Then there is an automatic mechanism how you actually pay back the following year for the overused quotas, and those decisions of the Commission can then be challenged, like Spain has challenged several times that. But they don't, that's more really EU law things. You have annulment actions against EU institutions. This is one of the Polisario cases, which is now pending. It concerns specifically the fisheries agreement between EU and Morocco. the arguments are very sort of, they go self-determination, the status, so all these very basic fundamental questions of international law. But it is pending till the previous case, the Western Sahara campaign, is being decided, because it will deal with overlapping issues. So there are three that sort of Western Sahara cases. Then there are all kinds of cases between EU institutions, where again, UNCLOS can be part of the legal environment where EU legislation and EU acts are being interpreted, sometimes to a surprising extent. ITLOS, we call this ITLOS case simply because it was a case brought by the Council against the Commission during the proceedings of the advisory opinion. So there were on two sides actually law cases, one in Hamburg and another one in Luxembourg, because the Council challenged Commission's ability to decide when to intervene in a case before an international tribunal. So in the end, the court came in favor of the Commission, considering that it is the role of the Commission also not only in domestic courts or in Brussels, but also in Luxembourg, but also in international tribunals. But, and the other cases here, the Weddell-Sea cases, are pending. These are not so interesting maybe to general audience, but they are just illustration that you have this axis of disputes between institutions, and law of the sea plays a part. That concerns the Antarctic area and the determination of the MPAs there under Kamilar Convention, where Commission is saying this is exclusive competence, and the Council is saying that no, this is also involves the member states. But that is more the sort of intra-institutional dispute that we have. Also, this one is an interinstitutional question. From international law point of view, it's more interesting in the sense that it concerned, and there's a judgment for it, so it concerns, there was a difficulty in negotiating with Venezuela at the time between EU and Venezuela, and the Commission considered that it is not ready to enter into international agreement with Venezuela, and it came with the idea that we do it by way of a unilateral act inspired by the nuclear test case, that you give fishing rights in the area which is French Guiana, which is in the area of EEZ, EU EEZ area, and it treated it as if it were an instrument equivalent to a treaty. Advocate General Sharpston agreed with that and thought that, yes, the treaty-making procedures apply by analogy, but the court came with a much more complicated explanation, which may be interesting to look at. It construed that this unilateral act actually constituted an agreement by way of exchange and behavior with Venezuelan authorities, but it looked at it from the viewpoint of the role of coastal states and flag states, and was taken by the motive that actually you need to have not only the permission of the coastal state, but commitment of the flag states in order to allow it in the EU waters. I'm not sure if all of you would go along with that construction, but that's what the court did in that case. But basically, it did it all by way of looking systematically UNCLOS provisions, and by looking what is the role of the coastal state, what is the role of the flag state, and then it construed this act, initially unilateral act, practical issue was here that it had to decide, do the treaty-making procedures involving European Parliament, do they apply or not? So it was very much internal EU procedural issue, but it was the legal surroundings were against the UNCLOS background. Then we have, of course, EU is before various international tribunals. We've had two fisheries-related cases, one with Chile and another with Faroe Islands. Both of them, there's no final award. In both cases, it's, they were settled by way of negotiation, the most usual dispute settlement method, what is available and practiced in the world. But it was done while cases were pending in UNCLOS Annex 7 arbitrations. EU doesn't have a particular problem with these international tribunals, and it is also, these days, it's not particularly questioned whether it can actually be a party in these things. I think maybe the rationale may have been problems in the beginning. I think the rationale is basically that people just get used to it, that EU has certain competencies, and in order to get a remedy, you have to turn to the one which can then deliver in case of changing legislation or whatever comes into place. In any event, that's been the story very much in the WTO. There too, it's less of a problem, even though also the member states are party to WTO, they are party to UNCLOS. But so these have been the case, and there were ITLOS advisory proceedings. This was also a highly controversial issue jurisdiction of ITLOS in this case. Member states were completely split up in the decision, in their position on whether ITLOS has jurisdiction or not. On the Commission side, Commission was much driven by the fact that it had IUU fishing as the topic, and that was pretty much the motivational factor that it wanted to highlight the IUU fishing, the importance about it, and was quite pragmatic about jurisdiction, saying without prejudice we make these comments and interventions on the substance of the dispute. And later on, actually, it's detailed, but it may be mentioned that whatever is the value of these advisory opinions, is that nevertheless it's been used in the subsequent legislative process in Brussels by way of a proposal regarding management of external fleets, because this has an interesting paragraph relating to responsibility of international organizations, basically saying that international organizations are responsible for violation of their due diligence obligations of the vessels flying under the flag of the member states. So the Commission was inspired by that case for a piece of legislation which tries to improve the management of external fleets of the EU in the face of eventual responsibility for violations. So it has worked to some extent as the practical thing in that regard. Comment on the choice of means. Negotiation is really the king dispute settlement method, and the EU has, for instance, a lot of bilateral agreements. There are no dispute settlement provisions going to any court at all, and it has agreements with practically all countries along the African coast. So these are handled by way of negotiations. It's not really disputes, but which have come out, but the process of working goes through negotiations in joint bodies which are in place and established by those bilateral agreements. It operated, as I noted already, in the Faroe Islands and the Chile European Community case, as they were both settled by way of negotiation. Then there is the issue of split jurisdictions. Both of these cases is that there were parallel proceedings in WTO and UNCLOS, and of course then one is in two fronts, and neither of the parties were really clearly willing to leave it to either tribunals in Geneva or Hamburg to address the respective sides of the disputes, but they, in a way, they took it in their own hands, negotiated the settlement in this. But this is inevitable. It was mentioned earlier. It comes up also with this new agreement, new implementation agreement. How do you deal with the WTO issues? But it is a problem in the fisheries, for instance. It's not a unified circle because the end products are fish products and they are being traded, so they are more or less in the regime of the WTO after that fact. Then you can participate in advisory opinions, I mentioned. Then there is unilateral action. EU is quite ready to take unilateral action. There is legislation for that relating to IUU fishing and unsustainable fisheries fishing. That means basically that if there is readiness to take such action, there is also a higher likelihood you may end up to international tribunals. But so far, for instance, the Faroe Islands case was the application of this regulation of unsustainable fishing, because that was the EU's view that there's unsustainable fishing. It banned imports, and that triggered then were in the WTO and Annex 7 arbitration. And conciliation, there's no, that's the last point, there's no experience. I was on conciliation, I was listening with great interest the presentation of conciliation, and it came to my mind that maybe fisheries disputes in particular, if there are changing in the patterns that fish is moving, and there is question of scientific evidence and all the rest, maybe that could be alternative way to settle disputes, because UNCLOS is very zonal. So once the fish goes to another zone, it's another legal situation, and maybe conciliation could be. I think I leave it to that. So this is in the overview. I'd be happy to try to answer any questions if you have later on. Thank you.
Yes, thank you. I guess my time starts now. Thank you. Like all the other speakers that have come before me, I really want to thank the organizers, Professor Luis Fabrice, and especially Marco and Tamar, for inviting me here, and of course the sponsors for making it all possible. But I have to admit, I'm more than just a little intimidated to be speaking before such an august audience and in front of people who have infinitely more experience in the actual practice of international law than I have as an academic. But I'm going to try to do my best to fulfill my part of the bargain of keeping you awake after lunch as well. And I should say that as an Australian, I'm used to occasionally falling asleep while I myself am speaking, so it's okay. But I've been asked to speak today on dispute settlement in regional fisheries management organizations, those RFMOs, which is how I will refer to them. And for those of you who don't know, what I'm referring to are the organizations that have been established under international law to deal with fisheries on the high seas. And I confine my comments to agreements that establish actual organizations for the conservation and management of high seas fisheries, not other types of arrangements. So the first point that I want to say is that it's worth remembering that the essential purpose of an RFMO is to provide an effective forum in which states can agree on fisheries conservation and management measures. And the fundamental legal basis of the work of RFMOs is the duty of states to cooperate in the conservation and management of living marine resources as laid down in the Law of the Sea Convention, of course. And that broad duty of cooperation, which we know forms part of customary international law, has both a positive and a negative aspect. And the positive aspect relates to the requirement that states have to seek to reach agreement with other states. And that was articulated by the ICJ in the North Sea Continental Shelf cases as meaning that the parties are under an obligation so to conduct themselves that the negotiations are meaningful, which will not be the case when either of them insists upon its own position without contemplating any modification of it. The negative aspect of the duty to cooperate refers to the idea that states have to refrain from taking unilateral actions whether or not agreement has been reached. And that, of course, has a bearing on the legal situation when disputes arise between states or members of organizations when they vote against a proposal that otherwise attracts necessary support for adoption of that decision. And in both cases, the duty to cooperate is going to apply, and it's going to impose certain limits on the nature and scope of any unilateral action that the disputant or the objector can take. And the duty to cooperate in RFMOs is, of course, manifested through the conservation and management measures that these organizations adopt. And, of course, there are different types of decisions. First, we have decisions relating to administrative, budgetary, procedural questions. I'm not really concerned about those. What I'm concerned with today are the decisions that are taken about conservation and management measures. And these decisions are at the very heart of the work of RFMOs. And the subject of these measures, of course, varies from everything from very technical measures relating to mesh sizes or fishing seasons or reporting obligations through to monitoring, control, and enforcement obligations, and perhaps the most sensitive of all, establishing total catch limits and allocating fishing opportunities. And these decisions with respect to TACs and quota allocations raise particularly complex issues and very heated debates, and are often, though not exclusively, the source of differences and disputes between the parties. And so we need to have decision-making processes that can deal with the ability of states to opt out of the application of these decisions and can deal with the fact that states have opted out, because a number of RFMOs do allow states to opt out of decisions or to file objections to decisions so that those decisions are no longer binding on that particular state. So it's critically important that RFMOs have in place some sort of a mechanism for resolving disputes and disagreements that arise as a result of this process of agreeing on conservation and management measures. Now, the issue of dispute settlement in RFMOs is not particularly new. I'm sure you will all be familiar with the fact that it came to our attention most notably in the 1990s when Canada, which is where I'm originally from, went out and arrested the Spanish fishing vessel, the Estai, in the NAFO regulatory area beyond the 200 nautical mile limit during a broader dispute between Canada and Spain and the EC relating to the settling of turbot quotas in NAFO. At the time, it was important to note that neither Canada nor Spain were parties to the Law of the Sea Convention, and of course the fish stocks agreement didn't yet really exist, and so Spain attempted to bring a case to the International Court of Justice under the optional clause declarations, but that case of course foundered when the ICJ said it didn't have jurisdiction. Similar result occurred in the southern bluefin tuna litigation when Australia and New Zealand brought proceedings against Japan under the dispute settlement provisions of Part 15, arguing that Japan was overfishing southern bluefin tuna in violation of the Convention on Southern Bluefin Tuna. Japan had a proposed experimental fishing program which Australia and New Zealand had already rejected, but Japan decided to go ahead with it unilaterally anyways. The case went first to ITLOS for provisional measures, which were, in fact, prescribed, and that included catch limits that were set on all three parties. But when it got to the arbitral tribunal that had been established under Part 15 of the Law of the Sea Convention, the tribunal said that the combined effect of Article 281 of the Law of the Sea Convention and the dispute settlement article in the Convention on the Conservation of Southern Bluefin Tuna meant that the tribunal had no jurisdiction. So the decision was actually seen as a significant blow both to the environmental movement and to the carefully crafted compulsory jurisdiction provisions of Part 15 of the Law of the Sea Convention. And we've also heard about the 2000 dispute between Chile and EU and the swordfish dispute, which sort of flashed across our screens. The EU taking proceedings in the WTO, Chile taking proceedings in ITLOS. We'll never know what the outcome was because it was settled, and similarly with the Faroe Islands dispute. But what these examples, and in particular the Southern Bluefin Tuna cases, demonstrated was the very real need for some form of more effective dispute settlement mechanisms within RFMOs, ones that could actually be utilized without falling foul of jurisdictional issues. And these international standards were essentially established in the Fish Stocks Agreement in 1995, Article 27 of which provides for the general obligation to settle disputes by peaceful means, including negotiation, inquiry, mediation, etc., that we've all seen. Article 28 requires states to cooperate in order to prevent disputes. And to this end, it goes on, states are required to agree on efficient and expeditious decision-making procedures within RFMOs and to strengthen those decision-making procedures as necessary. And then Article 29 says, well, where we've got disputes of a technical nature, the states concerned can refer that dispute to an ad hoc expert panel established by them. So here we're seeing the beginnings of dispute settlement procedures internal to RFMOs. And of course, we also heard from Lisbeth earlier today about Article 30 of the Fish Stocks Agreement, which makes Part 15 of the Law of the Sea Convention apply mutatis mutandis to disputes relating to the interpretation or application of the Fish Stocks Agreement, but importantly also makes Part 15 of the Law of the Sea Convention apply mutatis mutandis to disputes concerning the interpretation or application of conventions establishing RFMOs and other regional agreements. So the effect of those provisions is to apply the arrangements of Part 15 of the Law of the Sea Convention to several categories of dispute that arise partly outside the scope of the Law of the Sea Convention itself, including disputes about the Fish Stocks Agreement, about the terms of the constitutive agreements of RFMOs, or about conservation and management measures that are taken by RFMOs. Of course, there is one limitation with the provisions of the Fish Stocks Agreement, and that is that the Fish Stocks Agreement only applies to its parties. So what do you do if you have an RFMO in which some of the members are not party to the Fish Stocks Agreement? Well, an interesting provision was put in the Western Central Pacific Fisheries Convention that deals with this limitation. It provides that the provisions relating to the settlement of disputes set out in the Fish Stocks Agreement apply mutatis mutandis to any dispute between members of the Commission, whether or not they are parties to the Fish Stocks Agreement. And that provision has been repeated in other RFMO agreements as they have been modified post-1995. So basically, you have agreements applying whether or not states are parties to the Fish Stocks Agreement or the Law of the Sea Convention, as long as they're party to an RFMO that has the relevant provisions in place. And a similar approach has been adopted in the now revised NAFO Convention and in the NAFO, I hope you know, North Atlantic Fisheries Organization, SIAFO, Southeast Atlantic Fisheries Organization, and the South Pacific Regional Fisheries Management Organization, which is referred to as SPRIFMO. In the NAFO context, the revised NAFO Convention provides that disputes about adopted measures or objections to them are going to be considered first by a non-binding ad hoc panel as a matter of urgency. If its recommendations are accepted, all very fine and dandy, they're implemented without delay. If the panel's report is not accepted, then any party can refer the dispute to a binding settlement procedure as in Part 15. In other words, so future disputes like the Canada-Spain dispute won't arise in NAFO. And of course, the important thing here is that the dispute settlement arrangements in RFMOs should not reduce the scope of the possibilities below the level of the benchmark set in the Fish Stocks Agreement. And the NAFO convention actually goes on to make sure that that doesn't happen by stipulating that any party that is already bound, nothing in the NAFO convention prevents a party that is already bound by the Law of the Sea Convention or the Fish Stocks Agreement from submitting a dispute to binding procedures. But that still doesn't get us away from the fact that we sometimes need rather more expeditious and efficient dispute settlement mechanisms. And particularly this has arisen in the case of the opt-out procedures, or the ability of states to object to measures. So we want infinitely more expeditious ideas to resolve matters in-house. And that's particularly true in respect of disputes that relate to opt-outs exercised in the context of decision-making. And as we know, it's an unusual feature of many of these RFMOs that member states can submit objections to conservation and management measures, and the problem is that by doing so, then we have to be careful that they're not actually, the objection procedure is not undermining the conservation objective of the organization. And the review conference of the Fish Stocks Agreement actually recommended that RFMOs should ensure that post-opt-out behavior is constrained by rules to prevent the opting out parties from undermining conservation. There should be clear processes for dispute resolution, and there should be a description of alternative measures that could be implemented in the interim while a decision is being made on the validity or otherwise of the objection. And provisions seeking to accomplish this have been adopted in a number of RFMOs. In the Western Central Pacific Fisheries Commission, for example, members contesting or opting out of a decision can seek its review by an ad hoc review panel on the grounds that the decision is inconsistent with the provisions of the Western Central Pacific Convention, the Fish Stocks Agreement, or the Law of the Sea Convention, or the decision unjustifiably discriminates in form or in fact against the member concerned. And we have, pending the findings of the recommendations, the review panel, the operation of the measure that has been objected to is essentially suspended. And of course, if the review panel finds that the Commission's decision needs to be modified, or amended or revoked, then it must be, but if it doesn't, then it isn't, etc. And we have similar provisions in the NAFO convention and in other conventions. I won't bore you with the details of all of those conventions, but suffice it to say, the important things to note from a procedural point of view are that these procedures articulate the standard against which the objection is to be reviewed. Usually it's unjustifiable discrimination, or that the measures objected to are inconsistent with the relevant convention, or with the Fish Stocks Agreement, or with the Law of the Sea Convention. They all seek to require an objecting party to articulate alternative but commensurate action to be taken on their part to ensure that the measures are not further undermined. They all set very short timelines to ensure expeditious resolution. So panels have to be established and come up with their responses very, very quickly. They provide for decision by majority of the 3 panel members. They have provisions for the establishment of the selection of the panel members. The decisions of these panels are generally, in most of the organizations, considered to be non-binding, but of course they are persuasive. And of course they provide for delivery of panel decisions even where one party refuses to participate in the proceedings. Of course, it's worth noting that not all RFMOs have these procedures in place, but increasingly they are being developed. There are, of course, problems, though, with them coming into force. The Northeast Atlantic Fisheries Commission adopted an amendment to its convention in 2004 calling for the establishment of such sort of a procedure within the Commission. They adopted recommendations relating to the procedures, and I think everyone thought that they were in force until 2013 when Russia filed an objection to the amendment, so the procedures for the establishment of ad hoc panels in NEAFC are on hold until that objection is removed. The NAFO system itself, even though it was adopted in the early 2000s, has only just come into force officially as of May 2017 when the new amended convention came into force. And so the Western Central mechanism, the CIAFO mechanism, they've never been tested to date. In fact, the only place where this mechanism has been tested to date is in the South Pacific Regional Fisheries Management Organization in SPRIFMO. And that was in a 2013 dispute between Russia and the other members of SPRIFMO in a dispute revolving around the allocation of fishing opportunities, which of course is one of the most contentious issues that confronts RFMOs in general. And I'm just going to talk a little bit about this dispute. You heard a bit about it yesterday, and I know one of the panel members is sitting in the audience, and I'm sure he can correct me on anything that I get completely wrong, which is entirely possible. SPRIFMO was established pursuant to the Convention on Conservation and Management of High Seas Fisheries Resources in the South Pacific Ocean, with the objective of ensuring long-term sustainable use of non-tuna fishery resources in the South Pacific Ocean and safeguarding the marine ecosystems there. It was adopted in 2009 after many years of international negotiations. The convention came into force in 2012, and the Commission held its first meeting in 2013. One of the stocks of particular concern to the negotiating parties was jack mackerel. I won't bore you with the Latin name. Catches of jack mackerel had increased exponentially during the 90s and then crashed and declined. And when the negotiations for the convention began in 2006, everyone knew that they were going to have to do something serious to look after this jack mackerel stock. So they adopted a number of interim measures to get the research done so that they could know what the status of the stock was. And revised interim measures were adopted year after year, basically saying, well, we have to be very careful. And in 2010, it became clear that immediate catch reductions were necessary. According to the chair of the preparatory conference for the Commission, the jack mackerel stock was quite possibly the most depleted major fish stock under the responsibility of any RFMO anywhere in the world. So there was a serious problem with this stock. And in 2011, the preparatory conference adopted additional interim measures calling for very significant reductions of catches. So that's the background. At 2013, the first meeting of the Commission, everyone realized they had a problem and they needed to act fairly expeditiously and urgently to reduce the catches of jack mackerel. And so the Commission adopted what was effectively a one-year emergency measure, setting an overall TAC, total allowable catch, for the stock. And it then proceeded to allocate national quotas based on a percentage established in accordance with 2010 catches. But no quota was allocated for Russia, which is a party to the agreement, and a member of the Commission. And needless to say, Russia immediately objected. Why have we been left out of a quota allocation? According to the documentation, the reason for the omission of Russia from the quota allocation was because there was no reliable data to prove that Russia had, in fact, been fishing in the area in 2010. Now, Russia had notified the interim secretariat in 2009 that it would have a vessel fishing in the area, but information seemed to indicate that this vessel was not a fishing vessel. It was, in fact, a fish processing vessel, which was totally incapable of conducting any fishing operations. And it seems that the fish that were on board were fish that had been transshipped and were actually caught in the Peruvian exclusive economic zone. So here we have a case of, well, are they trying to doctor the numbers? Now, as I mentioned, the SPRIFMO Convention has a procedure which allows for objections, but the only admissible ground for an objection is that the decision in question unjustifiably discriminates in form or fact against the member of the Commission or is inconsistent with the provisions of the SPRIFMO Convention or other relevant laws reflected in the Law of the Sea Convention. And so the objecting party is then required to adopt alternative measures of equivalent effect to the one objected to. And of course, Russia considered that the decision refusing it a quota unjustifiably discriminated against it, and it told the Commission, we're going to adopt alternative measures that give us the quota that we think we're entitled to based on our 2010 numbers, which, had they fished for it, would have sent the TAC wildly over what was recommended by the scientists and what was determined as being necessary. So the formal procedure under the convention was invoked. And The review panel that is provided for was established. It's established in April. It met in June. And it came up with its decision in July. And the decision appears to respect state sovereignty and the need to conserve and manage a heavily overfished and threatened stock. But I have to suggest that it failed somewhat to acknowledge the underlying challenge of the manipulation of data. But in any event, the panel did consider that the Russian alternative measures were not equivalent and ordered Russia instead that it could only authorize its vessels to fish once it was clear that the TAC was not going to be met by other vessels. Now, the case raises a whole host of interesting issues, but leaving aside all of those, the central issue relating to data accuracy, legitimacy, and compliance with adopted measures, it seems that the review panel, which we can talk about at length later, may have been justified for a whole range of reasons in taking this very constrained view of its jurisdiction. But I'm not sure that, while this may be one where it won the battle, it might not have won the war, because query whether these kinds of decisions actually do result in effective conservation and management ex post facto, given that Russia now has a quota in the Commission which is approaching the quota that it thinks it should have had, and all that's happened is the TAC has increased every year to accommodate Russia, even when the scientific evidence suggests that it shouldn't. So I will stop there, and that is my version of the dispute settlement procedures in RFMOs to date. Thank you.
Right, well, thank you very much. And let me also thank the organizers. It's a great pleasure. Have you got the clicker? Thank you. I realize I'll need that. To speak about the International Seabed Authority and deep seabed disputes, particularly as there have not been any deep seabed disputes. So it could be a rather short talk. But there are some very interesting legal provisions that raise some very interesting legal issues, and I'm sure there are a lot of potential papers to be written and a lot of very interesting research to be done by young researchers. Deep seabed mining. So the image you are looking at is the world's first purpose-built deep seabed mining vessel. It's currently in dry dock in China, 225 meters long, 40 meters beam, very, very large and very sophisticated vessel. Deep seabed mining requires very new technology, very complex technology, and in many respects, untested technology. It takes place very far from land. Most of the deep seabed mining sites allocated by the authority are at least 5 days away from the nearest landmass. The depths at which it takes place are very deep, often more than 4,000 meters. And so we can see there is potential for various things to happen. There are potential accidents, potential incidents, potential disputes, and even potential problems relating to the marine environment. Of course, many of the disputes that might arise could be rather straightforward, turning on points of simple contractual interpretation or regulatory compliance, but there is still the risk of much more significant disputes which may be of very high value and with potentially wide legal and practical significance. So to deal with these disputes, the Convention establishes the Seabed Disputes Chamber as a specialized chamber of the International Tribunal for the Law of the Sea. And perhaps the most immediately distinctive feature of the dispute settlement mechanism is that, unlike the dispute settlement provisions that are contained in Part 15 of the Convention, most of the provisions available in Part 11 are available to entities other than states parties. Well, today I'm going to speak primarily about the contentious jurisdiction of the Seabed Disputes Chamber. And in particular, I want to take a closer look at the provisions of Section 5 of Part 11 to look at the sort of disputes that may arise once deep seabed mining starts and that may be dealt with by the Chamber. And I also want to take a few moments to look at potential disputes that do not seem to be covered by the provisions of Section 5 and consider how those may be resolved. I don't today intend to say very much or even anything really about the advisory jurisdiction of the Chamber, even though, as you know, it's only the advisory jurisdiction that has been invoked so far. Much has already been written on this, on case number 17. I myself spoke about it in Hamburg earlier this year, and I really don't think I have very much to add on the topic today. I also want to mention at the beginning that some of you might be aware that the authority has just recently issued draft regulations for exploitation of marine mineral resources. These are out for public consultation until the end of the year, and they include several provisions that are relevant to the topic of dispute settlement. And I'll mention those again a little bit later. Now, my paper contains quite a bit of information about the background to the development of the provisions in Part 11. I'll skip over it for the purposes of the presentation now, except to point out that it was recognized right from the beginning, right from 1969, that there would need to be a separate dispute settlement mechanism for deep seabed mining disputes, in particular to deal with disputes that might arise where a state wishes to challenge the exercise of its powers by an international body. And this was considered necessary to establish a specialized review procedure for this purpose. There's a great deal about this in volumes 5 and 6 of the Virginia Commentary, and I must say that Alex's new book is very good on this. I had to read it last week, and it was very good on this aspect, and I recommend it. But let me go straight to the relevant provisions of Part 11 that deal with the jurisdiction of the Seabed Disputes Chamber. They are relatively short. They give the Chamber extensive, in some respects exclusive, but not exhaustive jurisdiction over a wide range of potential disputes arising from activities in the area. And I should mention here that the phrase activities in the area is a term of art. It's used extensively in Part 11 to qualify and limit the jurisdiction of both the authority and the Chamber to activities of exploration for and exploitation of deep seabed mineral resources. It's a very important definition, and I will come back to it later in the presentation. So the scope of the Chamber's jurisdiction. We need to look at Article 187, which sets out the various actors that are affected by the jurisdiction of the Chamber. They include states parties, the authority itself, of course, contractors with the authority, and contractors with the authority may be a combination of states parties, state enterprises, natural or juridical persons sponsored by states, or the enterprise. And they include prospective contractors. And again, the category of prospective contractors includes within it a number of potential actors. So Article 187 provides for jurisdiction over disputes between a state's party and the authority concerning violations of Part 11, its annexes, and the rules of the authority. Disputes between a state party and the authority concerning acts of the authority that are alleged to be in excess of jurisdiction or a misuse of the authority's power. Disputes between parties to a contract. Disputes between the authority and a prospective contractor, concerning the refusal of a contract, disputes between the authority, state party, state enterprise, or a natural or juridical entity concerning liability of the authority, and any other dispute for which the jurisdiction of the chamber is specifically provided for. Article 188 is the big but, because it makes clear that the jurisdiction of the chamber under Article 187 is not compulsory in all cases. So certain disputes may be referred not to the chamber, but to other fora. So, for example, disputes between states parties under Article 187A may be referred at the request of any party to the dispute to an ad hoc chamber of the Seabed Disputes Chamber, or upon the request of all parties to a special chamber of the full tribunal. Disputes between parties to a contract shall be submitted at the request of any party to the dispute to binding commercial arbitration. Now, there's an important proviso here that I think was mentioned earlier, that a commercial arbitral tribunal shall have no jurisdiction to decide any question of interpretation of the convention. And that question, a question of interpretation, must be referred back to the chamber for a ruling. Where such a ruling is required, that ruling has to be obtained first, and the arbitral tribunal must then render its award in conformity with the ruling of the chamber. There are also some important limitations on the chamber's jurisdiction in Article 189, which provides that the chamber shall have no jurisdiction with regard to the exercise by the authority of its discretionary powers, nor shall the chamber pronounce itself on the question of whether the rules, regulations, and procedures of the authority are in conformity with the convention. So that's disputes that are within the jurisdiction of the chamber and the alternative means of dispute settlement. What about disputes that are outside the jurisdiction of the chamber? Well, there's quite a lot that could potentially fall outside the jurisdiction of the chamber. And they really fall into two categories. First category are those which seem to be excluded by the language of Article 187. So these include, first, disputes that do not concern activities in the area. Remember the phrase that I referred to. And a very important clarification was given to this term by the chamber in case number 17, which made it clear, for example, that activities such as processing of minerals on land, as well as transportation of mineral ore from a mine site to the shore, are not considered activities in the area. So they would be excluded from the jurisdiction of the chamber. It also implies a spatial limitation, so disputes that do not take place wholly within the area or in respect of it will also be excluded. There's a category of disputes that may concern the authority but arise under other parts of the convention other than Part 11. Such disputes would not be subject to the jurisdiction of the chamber if they are not in violation of Part 11 or its annexes. So, for example, disputes concerning interference with the rights of third parties on the high seas under Part 7, disputes under Part 12 on protection of the marine environment, disputes under Part 13 over marine scientific research. And then there's the very specific language of Article 187(c)(2) in relation to disputes between parties to a contract, which require that the act or omission complained of must be directed to the other party or must directly affect its legitimate interests. So it's not enough that it's just a dispute relating to a contract. It has to qualify under the language. The second category of excluded disputes is where one or more of the parties involved is outside the chamber's jurisdiction. So some of the more obvious ones might include, for example, disputes under Article 142 between a contractor and a neighboring coastal state, which it relates to an issue lying across the limits of national jurisdiction. Disputes between neighboring contractors, for example, collision of contractor vessels, or where one contractor encroaches on another contractor's area. And disputes with third parties, third-party users of the high seas, for example, or cable layers, pipeline layers, or a vessel conducting marine scientific research. And then, of course, disputes involving non-states parties. Of course, it is possible that some of these disputes might find their way to ITLOS under other provisions of the Convention or another multilateral agreement, but the question would then arise whether ITLOS itself, as opposed to the Chamber, would have any jurisdiction in respect of the authority. And the question as to whether the authority might have any right to intervene in ITLOS proceedings, because it is not a state party. It's equally possible, of course, that many of the disputes I just described, particularly those involving non-state actors, wouldn't find their way to ITLOS at all, but would be dealt with in municipal courts, where presumably the authority would be immune from suit. So, what are some of the conclusions and implications that we can draw from this very brief discussion? Well, first, I think it can be concluded that the jurisdiction of the Chamber is perhaps so specialized and so circumscribed by the wording of Article 187 and 188 that the number of disputes that will actually reach the Chamber is likely to be rather small. On the other hand, such disputes might well be very complex in nature, whether from a legal perspective or a technical or scientific perspective, and they may be procedurally complex in that they may involve multiple parties of differing legal personalities, whether states parties, international organizations, state enterprises, or private companies and individuals, or a combination of all the above. Second, the number of alternative scenarios for dispute settlement that are available in any given situation could perhaps lead to the development of divergent jurisprudence, especially on matters relating to the interpretation of contracts, which are perhaps more likely than other disputes to go to commercial arbitration under the jurisdiction created by Article 188(2), especially where they involve private entities. There might also be issues in such cases as to which arbitration rules would be applicable in any case, although the Convention itself does specify UNCITRAL rules by default. And then there is also a whole category of other matters that are regulated by the 1994 Implementation Agreement relating to GATT, or now WTO, issues that are excluded from the jurisdiction of the Chamber. And since we're dealing with commodities, it's possible that many disputes might arise in relation to WTO issues. Third, and people may disagree with me on this, but we might conclude, and I began to conclude as I was preparing this, that in many cases where its jurisdiction is likely to be invoked, the Chamber could be seen as a bit of a sledgehammer to crack a walnut. It's more likely than not that most of the disputes that will arise in the area will be really quite of a technical or administrative nature. For example, appeals against the imposition of administrative sanctions by the authority for regulatory breaches, or requests for review of decisions relating to operational matters. In such cases, is it really efficient to have disputes determined by a predominantly legally trained tribunal such as the Chamber? Perhaps some such disputes could be referred to an appropriately qualified expert or an expert panel, which is likely also to be much faster and cheaper than formal proceedings before the Chamber. This sort of procedure is in fact suggested in the draft exploitation regulations currently under consideration by the authority. So they propose, for example, a system of administrative review whereby a contractor may seek review of a decision made or an action taken by the authority to refer it to a single expert or a panel of experts. And then there's another provision in the draft that creates a type of administrative review mechanism with respect to things like the audit of royalty payments. It will be interesting to see if this approach receives broad support. And of course, your questions and comments and suggestions would be very welcome as the draft goes for public consultation. Fourth, I think there is scope for more clarification and understanding of the responsibilities of sponsoring states in relation to the activities of their sponsored contractors. And again, draft regulation 40 of the new draft requires that certain violations are reported by the authority to the sponsoring state so that the sponsoring state can take action in municipal courts. Does this imply perhaps that municipal remedies should be exhausted before there is recourse to dispute settlement under the convention? I don't know the answer to that. And then fifthly, I just want to mention Article 285. It's an interesting article. I must say I hadn't really noticed it before. And actually, as drafted, it makes absolutely no sense whatsoever. So I'm very grateful that Alexander's book actually makes it clear that it makes no sense, and you have to change the wording to make it make sense. But clearly what it means is that the intention is that the whole of Part 1 of Section 15 does apply to disputes that arise under Section 5 of Part 11. So we have to consider the importance and the possibility of conciliation proceedings and the necessity to exhaust the remedies in Part 1 of Section 15 before we go to the tribunal. That's my time is up, and those are my thoughts. I thought it was interesting as I, speaking on the a later panel, that in a way the issues that I've raised cover a little bit of almost everything that we've discussed today. So, as I say, no disputes yet, but lots of interest in legal issues to chew on. Thank you very much.
Well, thank you so much for all the speakers. Well, the final session is waiting for us, but still we can take a few questions, quick questions and quick answers. So if you have any questions, please raise your hand. Please. Yes.
My question is to Eric Franks from Brussels. My question is to Professor Paasivirta. The EU had at the time the EC had a lot of difficulty in getting its own position clarified within the United Nations Convention on the Law of the Sea, Part 15, because of course it's not a state and special amendments needed to be made. And of course we now have a special annex which tries to settle that within the 1982 Convention. And still we see that the EU by itself has not made a choice of forum. Is there a specific reason why the EU has not done so yet? Thank you.
Can I collect another question if there's any? Okay, then let's go.
It's true, at the time, as it didn't choose it. Can you hear me? Yeah, all right. So it fell on the Annex 7 by default. Is that, I think that I suppose the reality is that it is not very easy to revise your initial position in any basically political institution. You need some very concrete triggers. If, for instance, EU would choose ITLOS, I mean, it has to have reason for it. It is not merely to promote international law of the sea or this kind of promotional aspect about it. the reality is you need to have some concrete reason, and if you change your position, you often do in the context where some other amendments are taking place. So I don't see that coming in the immediate future. At least it hasn't been discussed. So I think that's the reason. But so did many others. It was a new tribunal, and so that's why it wasn't chosen at the beginning. Thank you.
So to decide not to decide doesn't really need reasons.
Correct. This is state practice.
Okay. Thank you. Any other questions?
Just a clarification on the last subject touched. Well, at the time, there were some member states that were in favor of the tribunal, and others were more for arbitration. And probably it was considered wise for the EU or EEC, as it then was, not to go either side. But then there was the rules of the tribunal, which are not so favorable to the participation of the EU as such. The mechanism for the participation of member states and of the EU, with the possible exclusion of certain judges which happen to be citizens of a member state, was not very encouraging, and the mechanism for an Annex 7 arbitration seemed more favorable to the participation of the EU.
Other questions? Yes, please, in the middle.
Thank you. Question for Michael. I'm sure that the ISA has followed very closely the BBNJ process, and the future legally binding instrument must have some sort of interaction with the area. Do you see any possible conflicts in both regimes?
Well, yes, thanks for the question. I mean, at the moment, there is only one regime, which is the regime for the area under Part 11. And it's, my feeling is that it's quite a comprehensive regime. We don't know what the shape of any future regime, if there is to be an additional regime, is likely to be. I think it was clear from Lisbeth's presentation earlier that the PrepCom has not exactly filled us with illumination as to what the shape of the future agreement, if there is to be an agreement, is going to be. So it's a little difficult to see. I think one concern has to be, though, that whatever new regime is adopted, it is an implementation agreement. I think that was the initial agreement. It would be an implementation agreement. I don't yet know which specific articles it is supposed to implement. No doubt we'll find that out. But as an implementation agreement, it clearly should not impact upon the existing arrangements in Part 11.
You mentioned that the importance of the definition of activities in the area, and of course part of that is the limitation to mineral, or if you prefer, non-living resources. Is there any indication that, faced with, if you were sitting up where I was, the looks on people's faces as the last speaker in the last panel before lunch was speaking, is there any indication that that reaction is giving rise to a rethinking of the potential role of the seabed authority, at least with respect to what one might argue are closely linked things such as hydrothermal vents and so on and so forth. Is there any such discussion? You may not be able to say, but it would be interesting to hear anything you thought you could say.
I think there was some discussion at an earlier stage in the PrepCom, or even actually in the working group prior to the PrepCom. But just as an observer, I think in the last few years, a lot of that seems to have gone away. And I think the language of the convention is quite clear. The mandate of the authority is limited to activities in the area. I think the advisory opinion produced really quite a restrictive interpretation of activities in the area. That is not to say, of course, that the authority doesn't have responsibility for environmental impacts of those activities that might impact upon other parts of the marine environment and would have liability for those, for any damage that is caused. But in terms of the operational mandate of the authority, I think it's rather clear that it's limited to activities in the area.
Thank you. Okay, then allow me to ask a final question to Rosemary. Any decision on the conservation and management must be taken on the basis of the sound scientific information and data, and you referred to the Russian case at the end of your speech. But what if the parties do not agree on the correctness or precision of the scientific information?
Well, that's going to depend on which organization you're in, because if there's a requirement for consensus, if they don't agree, there's no consensus, you don't get anything. If it's an organization which allows for some sort of a majority voting or an opt-out procedure, then you may get a measure, but you may end up with one party that doesn't agree with it.
Questions are determined by the vote of sovereign states.
Well, I mean, that's going to depend on all the different organizations. But ultimately, the adoption of the measure that the Commission itself adopts is going to depend on the voting rules. And if it's consensus and you don't get it, then no measure.
Thank you so much, and thank you for the rich questions and answers and speeches. Please join me in thanking all the panelists.